All persons having business before associate judges now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save this United States and its honorable court. This honorable court is now in session. Please come to order.
Thank you, and good morning, everybody, and welcome to the District of Columbia Court of Appeals virtual oral arguments. Welcome also to the, I'm sure, thousands of people who are watching on YouTube this morning, this rainy day in the District of Columbia. We have 3 cases on this morning's calendar, and we're going to change the order a little bit. The first one we will hear is number 18 AA 733 VIZION 1 Inc. versus DC Department of Healthcare Finance. And whenever you're ready, Mr. Temple.
Good morning. Thank you, Your Honors. The appellate would like to reserve 5 minutes for rebuttal, please. May it please the court. This case is not unfamiliar to this court, but we would like to at least tell the court the standard of review, which is the extent to which the lower court decision was arbitrary, capricious, or an abuse of discretion. And we would like to suspend partially with the facts, except to say this at the very outset. It is upon a close review of this record, both the lower court judge and the government here ignore the fact that there are not only contradictory versions of what happened below, as the administrative judge admitted in his footnote number 3, but he trivializes that. So I would like to point out to the court at the very outset, a significant and critical issue here is that Mr. Turnage, the executive head of this particular agency, on February 20th, moved in one direction and Mr. Shearer moved in another. The lower court statement of facts credited Mr. Shearer, basically saying that they met at a separate time and date, a separate time of the day. But it's much more egregious than that. Mr. Turnage testified below that at no point did he have any communication with Yolanda Brooks, who was with the public, the suspension committee, number 1, nor did he receive any report from Ms. Brooks, number 2, and that he had no communication with Mr. Shearer regarding that report. What that means is that the premise of the lower court's ruling and opposing counsel's argument is that Mr. Turnage relied upon the suspension committee's findings. That's flatly refuted by Mr. Turnage, but it goes even further.
Mr. Temple, can I ask you, if there's conflicting testimony on various of these aspects, wasn't it within the authority of the OAH administrative law judge to credit testimony from one witness as to one aspect of things and another as to another, and kind of piece together a picture that the ALJ thought made sense? And if the ALJ can do that, is that what happened here? And if so, what's our authority to step in and say the ALJ just couldn't reasonably have found the series of things based on the various conflicts among the testimony?
Thank you, Your Honor. First and foremost, that is the premise of the court's view is absolutely correct. However, in this particular case, this case is not that case. This case, there is no evidence here that Mr. Turnage made his decision. First and foremost, to get to the court's point, it is Mr. Turnage who made the decision to suspend Vision 1, not Mr. Shearer. It is Mr. Turnage's testimony that he did not rely on the suspension committee's notes, records, and the like.
Can I ask you something a little more concrete, though? I mean, that's very kind of inside baseball about which documents you relied on for what purpose. Is there testimony more specifically about what circumstances, under not what report was given to him when, or who he met with which person, when he met with which person, but what substantively what he was thinking about when he decided to suspend, and for example, whether he was focused exclusively on information relating to the criminal arrest of the 2 employees, or whether instead, at the time he was making his decision, he had in mind broader concerns about VIZION. Is there concrete testimony about that, rather than, again, who met where with whom and which documents got to whom, about which people could obviously get confused or have conflicting recollection?
Yes, to answer the court's question, there is concrete testimony. Mr. Turner testifies in his examination exactly to that point, and what he testifies to is that on that particular day, he met with his senior executive committee people. He discussed the fraud issues, and he indicated his interest in dealing generally with the fraud, not necessarily with good cause. His concern, and he also talks about, and he says in his testimony that he read the newspaper article which discussed the indictments of the individual employees. He did not say, he said that he barely read the indictment. So his concern was not only that there was fraud generally with Vision One, but fraud with the 16 providers. And there's extensive testimony in the record regarding that.
And so that seems to kind of undermine an aspect of your point. If your point is, the way I thought an aspect of your point more generally, I don't know if you've gotten to it quite yet, but I thought a legal component of your argument was, because of the factual points you try to raise, the way the OAH-ALJ was required to look at this case was to determine whether there was good cause to suspend VIZION based solely on the activities of the 2 employees who got arrested. Are you making that argument, or am I misunderstanding the point you're trying to make?
My argument is that the law is, first of all, the federal law governs, number one, and the policy that was put in play by the District of Columbia, dated February 1st, is the effective date, was the policy that should have been in play to govern the district's decision-making process. Number one, Mr. Turner did not admittedly rely on the policies. He relied on the federal regulations and said that he had not familiarized himself with those policies. Number two, in terms of the process and the decision-making process, you can't have fundamentally red and blue in this record regarding the decision. One thing happened or another. What we're arguing here is that the process here, that certain things that were said that have happened could not, both of these things could not have happened. If you believe Mr. Turnish, then Mr. Turnish violated both the federal law and his own policies and regulations. The suspension process required under the federal regulations and applicable policy that in the suspension review process, there is some consideration as to whether or not there's good cause. The case turns on good cause. In that particular context, Mr. Shearer.
Well, let me just step back a second and just say, do you think if it was open to the OAH-ALJ to say, I'm trying to figure out whether DC-HCF had good cause. And here are some things that I have in the record in front of me. And there are these 2, the criminal arrest of 2 folks, but then there's a lot of other information about other problems with VIZION. And so the OAH-ALJ is saying, look, well, that seems like, that information would amount to good cause. Do you disagree with that? Do you think that if all of the information that the OAH-ALJ is recounting and referring to is taken into account, DC-HCF could reasonably have concluded? I know you have a process argument, but just in terms of whether the evidence that the OAH-ALJ was referring to is enough to permit a good cause suspension, do you think it is enough or is not enough?
I don't think that it is enough, and I would point to court. The process is not minimal here, but I would point.
I mean, I'm not trying to minimize your process point. I'm just trying to pull apart 2 different kinds of arguments and make sure I understand how they interact. Well, but you just to focus again on the question I was trying to sort out before we shift back to process. Could you explain why you think that if we take into account the earlier investigations of VIZION and the various issues as they spun out, and then There's some later information also about what was discovered after further inquiry. Again, whether that's in front of us right now or not, I'm not sure, or in front of the OAHALJ, I'm not sure. But could you be a little more concrete about why you think all of the information referred to by the OAHALJ just wouldn't have allowed an agency to say, you know what, there's good cause to suspend here? Why would that not be good cause?
Well, first of all,
how would you explain that?
I'll try that. A lot of questions. I'm going to try to drill down, Your Honor, to answer them.
Well, let me try to make it really simple because it did have a long windup, but here it is. If you take all of the facts that are referred to in the OAHALJ's order, do you think that an agency that considered all of those could reasonably conclude there was good cause to suspend payments to VIZION?
Well,
that's my question. It's a very simple question.
Well, the facts are incorrect.
I know you. I'm just asking you again. I get that you have process objections and you may have, clear error kind of objections. But my question is still stands, which is, assume we don't agree with you about process, and assume we don't agree with you for the moment about whether any of these facts are clearly erroneous. And just asking, assume the facts were as they were described in the OAH order, and assume that the agency had considered them all. You with me so far? Could the agency reasonably suspend VIZION's payments if those facts are true and if they were all in front of, all considered by DCHCA?
If on February the 20th, 2014, there was evidence of a case that had not been settled and resolved and that was still before the agency head, and if there were an ongoing investigation, which I represented to the court as an officer of the court, I spoke directly to the FBI and the investigation was closed, and there was an ongoing FBI investigation and there was massive fraud which did not exist, then the court is correct. It would be good cause. However, that was not the case and that was not the record.
You said massive fraud. Why does it need to be massive fraud? I thought it was credible allegations of fraud.
No, I'm going to the judge's question, Your Honor, in terms of what the record says. When Judge Handy says that there was an abuse of fraud, there only has to be credible evidence of fraud. I'm not negating the fact that there's credible evidence of fraud, judges. I mean, that's the premise. I mean, there was an indictment, there's credible allegations of fraud. That triggers the federal regulations, which then sought to provide a very careful process. And we pointed out to the court the legislative history of that so that situations like this don't arise where you end up shutting down a large corporation for micro evidence of fraud. In this particular situation,
when you say micro evidence of fraud, that gets back to the question of whether all that is properly in front of the OAH-ALJ or all that was considered by Mr. Turnage was the incidents relating to the criminal arrest of the 2 employees, as opposed to all the other contextual information that the OAH-ALJ certainly took into account in determining whether or not the suspension was supported by good cause. And I know you have a process argument whether Mr. Turnage was thinking about all of that. I get that point.
I don't have a process.
But I'm not sure.
I have a context argument to that, Your Honor. I mean, the record shows that on February the 20th, on that particular day, that was the case. The issue was the indictments. Subsequent, because of the litigation, the intense litigation thereafter, which included litigation in the federal court regarding these suspensions, including injunctive relief motions filed by many of these providers, the story began to change. And that's critical because if you delineate from this record what was before Mr. Turnage and how Mr. Turnage approached this issue on the 14th, and then what he testified to when the government and Mr. Turnage started talking about a broader, more expansive record of fraud that didn't exist, then that was designed to do and to inform the court and to make the court believe that it existed. And we challenged that very aggressively, and there is no evidence. I would point out to this court, there is no evidence in this record where that settlement agreement that was entered into related to those that alleged overpayment was reopened. That was a court proceeding. That was a court documented settlement. There's no evidence. There is testimony about that, but there is no record evidence in that regard.
I'm not, again, so let me just make sure I understand it. If, let's say the situation was as follows. A company that had been accused of substantial fraud, and then there were, a lot of things that went on, and ultimately there was a settlement. Then has a situation where 2 of its employees get criminally charged with fraud. And DC HCFA is trying to decide, well, okay, should we suspend? And they say, look, we got credible allegations of fraud. The people have been indicted. And now we got to figure about good cause or not good cause. Here's why we think there's good cause. There was a huge inquiry. There were all these problems. There was a settlement. And now we got 2 new people doing this. That's good cause. Are you saying that if that's the record in front of the agency couldn't say, well, I think there's good cause to suspend, and an administrative law judge couldn't uphold the agency determination?
Absolutely. I'm saying that because it's not the administrative law judge, it's the federal law. The federal law in the Affordable Care Act, in reducing that standard from reliable evidence of fraud to credible evidence of fraud, was sensitive to the fact that—
Well, no, but again, there is credible. What you seem to be saying is there has to be credible evidence of the circumstance. They have to prove up. The credible evidence standard applies in some special way, not only to the fraud component of it, but also to all the circumstances being. Let me just finish my question. Do you think that the requirement of credible evidence imposed by federal regulation applies not only to the predicate determination about whether there is fraud, so they need to think about good cause, but it also requires to all of the circumstances that are being considered in making the good cause determination?
No, I think the law says that good cause, and the point is that there could be partial suspensions or complete suspensions. And in this particular case, the law was very clear about units of fraud or micro fraud. The law is not designed to shut down an 1,100 person corporation, 1,100 employee corporation, because 2 low-level employees were involved in fraud. There is no evidence in this record where the management, the owners, the officers were involved in fraud. And more importantly, to the question of good cause, if the good cause decision is made as the law requires prior to actually implementing the suspension, and that's consistent with the district's own policies that were enacted pursuant to the law, then the district would look at the good cause issues. And in this particular situation, what would have happened is that the subsequent March letter that was sent by Vision One's then lawyers to the government would have been in a record. And what it indicated to the government was, in addition to there not being any evidence of these overpayments, but that Vision One had implemented in a massive accountability system at all levels and had all the checks and balances and was meeting with the government to make sure everything was in play. What happened here in terms of the context is that it was much more political than legal. The government shut down 16 entities and then selectively decided which entities it would allow to reopen. It was very subjective, it was very arbitrary and very capricious. The fact that you have 2 versions, and the court is absolutely right, you can have different versions of facts, that's granted. But when you have 2 stark and distinct versions, more importantly, by the decision maker, then you have to ask the question, why does Mr. Shearer say this? Why does this committee say that it met? And where are the records? The records are missing. Even in Yolanda Brooks' affidavit, she says that they reviewed it and relied on the local policies and procedures. There is a ton of factual inconsistencies here in terms of the process and in terms of the actual decision. So in terms of the good cause, the law says, listen, you can protect. If there's a situation, particularly here, where Mr. Turner is rightfully upset about these indictments of these individuals, but the indictments did not justify, and I think the law says that it doesn't require or should encourage the full, complete suspension of an entity.
Okay, thank you, Mr. Temple. We'll give you a little more time on rebuttal, but we'll hear from Ms. Anderson now.
Thank you, Your Honor.
Morning, Your Honor. Stacey Anderson on behalf of the District of Columbia Department of Healthcare Finance. The court should affirm OH's decision in this case simply because there is substantial evidence in the record supporting its determination that the Department of Healthcare Finance complied with the federal regulations when it suspended for Medicaid provider payments in 2014. I do want to put the case in a little bit of context. This is a case about process and not about the substance of the liable allegations of fraud and whether there was good cause not to suspend. Vision One never challenged the reliable allegations of fraud in this case. And from the record, we know that Director Turnage relied on 2 reports of investigation, one from 2010 and one from 2012, to make that determination that there were reliable allegations of fraud in this case. The 2014 arrests he viewed as something that just lifted the earlier request from law enforcement not to suspend pending the outcome of their investigations. So the second component then is whether or not there was good cause not to suspend. And again, VIZION 1 did not present any evidence at the OAH hearing that would suggest there was a good cause basis not to suspend. They simply were arguing that DHCF did not go through the correct process in making the decision. And we know what the process was here because we have 2 witnesses and an affidavit that outlined that process. Mr. Shearer and Ms. Brooks talked about the Provider Suspension Review Committee meeting on February 20th, 2014, to consider each of the good cause factors. And Ms. Brooks' affidavit, which was executed just 4 months after the decision was made, probably contains the most detailed account of what the Provider Suspension Review Committee considered. And she outlines each of the factors that the committee went through and each of the reasons why they rejected the good cause basis for not suspending payments in this case. And then we turn to Mr. Shearer, who also testified about the Provider Suspension Review Committee meeting again to discuss these good cause factors. And then Director Turnage also spoke to the good cause factors in this case. One of the most prominent considerations for him was whether or not the beneficiaries would be able to receive the services in light of the multiple agencies being shuttered as a result of the arrests. So one of the good cause factors is whether or not, in fact, beneficiaries will continue to receive services. So he did look at that factor. And he looked at the remaining factors too, as he clearly testified before OAH. The record is clear. There's substantial evidence that supports OAH's findings on each of these factors. If there are no questions, Your Honors, we'd simply ask that the court affirm. Thank you.
Any questions?
I suppose
Okay.
I'll ask about footnote 3 of the ALJ's decision, stating that there was reliance on the committee, and Mr. Temple says, there's no evidence of that at all. What's your response to that?
Sure, I'd be happy to speak to that, Your Honor. I think there is evidence in the record. There is testimony from both Mr. Shearer and Director Turnage, and I've cited that on page 19 of my brief, footnote 14, where each indicated that there were multiple meetings that day and that Mr. Shearer was a participant in those meetings, the last meeting occurring in the evening, clearly after the Provider Suspension Review Committee had met. So although there is not direct testimony that, yes, we had this conversation about the recommendation, there was evidence that Mr. Shearer was part of the executive management team and the decision-making process. And I think it's certainly a reasonable inference, having met with the Provider Suspension Review Committee and come to a conclusion that conclusion would have been conveyed to Director Turnage during those meetings throughout the day. So that I think there is substantial support in the record for that finding.
And as to the conflicting evidence about when that meeting occurred, I suppose you just say that that's sort of immaterial, a sort of inconsistency that can happen when years pass between the occurrence and the testimony. Is that your answer to that?
I think I have twofold answers to that, Your Honor. First would be, yes, that would be an answer to that. But I also think when you review the testimony, going back through the transcript, there really wasn't a conflict. The question of whether Mr. Turnage was in the morning or not, there's just no inconsistent testimony about that. He met with his staff in the afternoon and the evening. Mr. Shearer and Mr. Turnage were consistent on that. And I've certainly set out that testimony in my brief. But to the extent that when they met is at issue, I think it is immaterial to the outcome of the case.
Thank you very much, Ms. Anderson. Mr. Temple will give you a couple minutes.
Your Honor, if I may direct the court to Appendix 156, and it's critical.
I'm sorry. 1 second. Appendix
156. Yes, sir. Transcript, page 142, line 10.
Thank you.
The government says that Mr. Turnage relied on Ms. Brooks and Mr. Shearer. This says about Ms. Brooks, did she participate in February 20th meeting? No. Do you know the extent to which she participated in a separate meeting to discuss the good cause exception for New Vision 1? No. Do you know the extent to which she participated in the provider suspension review committee meeting on that date? No. And when you say no, do you know whether such a meeting occurred? That is correct. I don't know whether such a meeting occurred and whether she participated in it did occur. And you didn't have any communications with her. I had no conversations with Ms. Brooks on that day. As to Mr. Scherer, directing your attention to Appendix 176, please. Transcript 222, 223. Excuse me, I'm sorry, that's Appendix 159, transcript 154 and 155. And 155, line 4, did you have any communication with Mr. Scherer before the afternoon meeting in which the suspension of these providers was discussed? I don't recall. It's not merely a question of a divergent time. The provider suspension committee had no communication with Mr. Turnage. Therefore, the fundamental premise of the court's—
Mr. Temple, it seems a big leap from, I don't recall whether something happened, to your stating that it definitely didn't and no fact finder could have found that it did.
Well, put that aside, Your Honor, with all due respect. I think that the question regarding Ms. Brooks is the point person, and she transmitted the memo, the form which Mr. Scherer relies on and the lower court relied on. That form was not transmitted to Mr. Turnage. More importantly, Mr. Turnage says that he had no idea that that committee was meeting. If he had no idea that committee, or no knowledge that that committee was meeting, he had no knowledge of anything that was happening on that side of the equation, then you can't have your cake and eat it too. You can't say, well, we're going to rely on Mr. Scherer and they did all these things, A plus B plus C plus D. And Mr. Turnage is saying, I have no knowledge that any of those things happened. It's oxymoronic. And so for the court in this particular situation to have to rely on concrete evidence, and it's not just that, we point out in our brief the consistent inconsistencies. The fact of the matter is they couldn't even find the records for these meetings. There's no documentation substantiating what Brooks talks about there in terms of the transmittal of a chart that's rank hearsay and the omission of the George Sherrer's document as a business record. All in all, I think that the record shows that given the context of the constitutional quagmires that exist that we're challenging in the federal court side here, process is critical. No business in the United States of America should be shut down because of a process where it's not clear and the government in making its decision on one hand is doing one thing and then doing another thing. And then the business owner is merely trying to follow the law and to comply with the law, notwithstanding that the DC municipal regulations said reliable evidence of overpayment. The policy said one thing, and the government is essentially doing what it wants. We think that the record is clear. There is no substantial evidence here to support the government's suspension decision. And we would ask that the court reverse the lower court's ruling. Thank you very much.
Thank you so much, Mr. Temple and Ms. Anderson. Thank you for jumping through all the virtual hoops to be with us today, and we will take the case under advisement.
Counsel, you can exit out. Thank you. Bringing in the next case, Judge.
Okay. The next case, the third case is number 9, the next case, second case for us this morning, but the third case originally, number 19 CV 937, REDSHIFT versus LAVONNE Shaw. Looks like we may have, okay. Hello, Mr. Gormley.
Good morning, Your Honor.
Whenever you're ready.
Okay, well, thank you, Your Honor. My name is Brian Gormley. I'm counsel for the appellant, REDSHIFT LLC. Please support. I guess I'm supposed to mention I'd like to reserve 5 minutes in rebuttal time.
Okay, thank you.
Thank you. So this is I think, relatively factually straightforward case. The REDSHIFT entered into a contract to purchase real property in the district with a LaVonne Shaw, the defendant here. And Ms. Shaw was, this property is owned by, or vested in ownership with Ida Bowling, who's long since passed away. Ms. Shaw represented to the manager, Jerry Jewell, of REDSHIFT, that she would open up a probate estate, that she was the only heir, and then, of course, proceeded after entering into the contract not to do anything for over a year. And so we're seeking specific performance or damages on the contract itself by virtue of some of the statutory, from the case law authority that we cited in our brief.
Can I ask you to clarify something factually that this may stem from my ignorance about how these things work, but why do we assume that Ms. Shaw could or would have, caused herself to be appointed the personal representative?
So yeah, sure. In probate law, and I appreciate it's a very technical area, and if you're not sort of accustomed to practicing in that particular area, it becomes very confusing. But under the statute 20-303, Ms. Shaw has both standing and priority to serve as PR. So the way it works is
counsel, that may be true, but is it also the case that the trial judge is not required to appoint someone who has standing and priority? That there is the authority in the trial judge to appoint someone else under the statute?
You have to have standing or priority or a consent, and that's actually what happened in this case.
I'm not sure you're answering the question, so let me try. Assume that I am an heir who and I try to become a personal representative of an estate. And I say, Judge, appoint me personal representative. And I say, look, I am I have priority here. I am on the list. There's no one who is alive who is higher than me on the priority list. So appoint me. My question is, can a judge, is that automatic? The judge is required to appoint me? Or under the statute, can a judge say, you are the heir, but I don't choose to appoint you? Do I find good reason to appoint some person who isn't you?
No, you have to have priority and standing, and the judge wouldn't have any discretion if you're the first petition in line. The judge is going to appoint you. I've never seen a probate court appoint someone on sua sponte on its own that wasn't a petitioner in front of it. If that petitioner,
my question is not a practical one; it's a question under the statute. Because although I was trying to pull the statute up, I don't have it ready to hand. My recollection of the statute is that it expressly confers authority on the probate judge, if for good reason or some language like that, to appoint somebody, any other person. If the judge decides not to appoint someone who has priority.
Well, no, I don't think so. I mean, there's a waterfall. That's the whole point of priority, right? That's the whole point of the concept of priority. The judge has to follow the statute.
No, I think that you can have presumptive priorities where you'll be first, and if that's what the judge ordinarily would do, but the judge has authority to do something different. So I don't know that it's logically incompatible with the existence of a priority provision that there is a residual authority in the trial court to do something different. But your view is the statute doesn't authorize that. Is that correct?
My view is that LaVonne Shaw contractually obligated herself to open up the probate estate, or in this case, reopen. And she has a contractual obligation, and Douglas v. Lyles affirms that. And I can read the language to you from the case. The opening up of a probate, or in this case, reopening, would be considered part of clearing title and selling a property. So she herself obligated herself to reopen that probate estate.
Yeah, but in Douglas and the other case you rely upon, all the heirs to the property had signed on to the contract. Here, you've got somebody who is 12.5%, I believe about 12.5% right to this property, purports to sign away the property in her own personal interest, not as personal representative of the estate. I mean, I would think the probate court could very well deny her personal representative status based on that act alone, that she tried to dispose of estate assets for her own personal benefit without taking into account any fiduciary duty that she had to the other heirs. And I would also think that the other heirs would have successfully objected to any sale because it wasn't for fair market value. What's wrong with thinking about it that way?
Because the probate court isn't going to interject itself in a contract dispute unless it's brought to the court's attention. And that's a different
Counsel,
question.
again, just to get back, I would have thought the heirs absolutely, the other heirs absolutely would bring it to their attention, and that the trial court would be cognizant of it anyway. But just to go back to the question, 2303D, the appointment provision says, exception, the court may, for good cause shown, vary from the order of priority to letters set forth in subsection A.
Okay, I don't think there would be any good cause in this case if a granddaughter with the highest priority.
Well, how could it? I mean, Judge Deal's question is, exactly the opposite. So assume for a moment it's true that Ms. Shaw purportedly, falsely claimed that she was the sole heir and purported to sell property. And then she goes into the probate court and says, appoint me personal representative. And other affected heirs say, wait a minute, she had a 12.5% interest and she's agreeing to sell the property for below its, substantially below its market value. Judge, don't appoint her. And if you do appoint her, in any event, wouldn't she then have fiduciary responsibilities to not sell out the interests of the other heirs? And wouldn't the judge be, I can't see how the judge would possibly approve that sale. So I don't see how this would work.
Okay, so that's, first of all, that's not the question before this court. Secondly, 12.5% has no bearing whatsoever on appointment as personal representative of an estate. The amount of, it's just
well, no,
about,
if the judge has discretion on good cause to not appoint someone a personal representative, that someone who had a 12.5% interest falsely claimed to have a full interest and entered into a contract to sell it, I would think that would have a ton of bearing on whether a judge would and appropriately could appoint that person a personal representative.
I personally disagree. That's not how probate works in my experience. And I
operate. Well, you've had cases where people who own, an eighth of property purport to have all of it and then try to sell it. I hope that's not a recurring phenomenon.
Okay, let me answer that in two ways. Number one, again, the percentage interest in real property is irrelevant to appointment as personal representative. And two, I have had many estates where there are many heirs and people have very small percentages, and someone has to get appointed as personal representative of the estate and act on behalf of the other heirs.
Yeah, that's true, but usually they're acting as personal representative of the estate, not under the false pretense that they themselves are the only heir to the estate and they can only act in their own self-interest. I mean, here there's no question that Ms. Shaw was not operating as a fiduciary in the way that she would have had to had she been personal representative of the estate, right?
So I believe that she was acting as a fiduciary, that is exactly what the Douglas v. Lyles case describes, that heirs can enter into contracts. There's language.
But again, in those cases, all the heirs were parties to the contract. And here you have got a 1/8 share of an heir who's pretending to dispose of the entire thing by herself. And by the way, the trial court's finding on the record evidence, and tell me if you think this is wrong, is that the contract itself permits of one conclusion, which is that it did not envision her going to probate at all. The 15-day closing suggests that it intended to be a non-judicial sale that was being envisioned in the contract. What's wrong with that conclusion?
Because it's not a non-judicial sale. The facts bear out that the parties attempted from day one to get a probate estate open, and that Ms. Shaw obstructed that process, refusing to take any action.
If she hadn't done it, if she had acted expeditiously, would she have been able to sell this property, been appointed personal representative of the estate, and been approved by a court within a 15-day time period? Is that conceivably possible?
She certainly could have been appointed.
Could the sale have gone through in 15 days as envisioned by the contract?
She certainly could have been appointed within 15 days as personal representative of the estate. That happens.
Counsel, that wasn't the question. The question was, is it, in your experience in probate, was it conceivable that she could have performed fully under the contract?
It is conceivable, in my experience in probate, that she could have been appointed as personal representative, which is required under the contract.
Did you hear the word fully in my question?
So the only reservation I have to answer, and I'm not trying to dodge the question. I'm sorry, Your Honor. I'm really trying to answer it candidly. there'll be two aspects in this case because it's a pre-95 death of the individual where title is vested. One is someone has to get appointed as personal representative. That certainly could have happened in 15 days. The second thing, because it's a pre-95 death, a court would have had to review a petition to approve the sale. That doesn't have to happen post-95 deaths, but that does have to happen pre-95 deaths. That it's conceivable, but I don't know how fast would the court. I've had it happen within a week or two where a petition has been filed and we've gotten approval from the court.
And do you think so you're saying you think in theory it is not impossible that, so I think your answer was yes, although it took a while to get there. Your view is that practically speaking, it would have been possible for Ms. Shaw, had what you claim to be her representation that she was the sole heir been accurate, that she could have, in theory, like the day after the contract was signed or the day the contract was signed, asked the judge on an emergency basis to appoint her personal representative, and at the same time say, judge, don't take this in two steps. Step one, appoint me personal representative. Step two, approve this contract for sale of the property. And your view is that it's theoretically possible that all of that could have happened within 15 days. Your answer is yes.
It's theoretically possible, sure.
And in your experience, have you ever seen anything like that happen?
As I said, I've had a court approve an estate within a week, and I've had many cases where the court appoints someone within about 7 days. That's the typical process for probate in DC, with no sort of ancillary issues like a will caveat or something like that. It's a rubber stamp process where you submit the petition and about 7 days later you get appointed as personal representative.
Can I ask a record question? Because I'm sure it's here somewhere, but I didn't find it looking quickly. I wonder if you can point me to it quickly. I know it is your client's assertion that Ms. Shaw represented that she was the sole heir. That's in the complaint. Is there a deposition or some other evidence to support that assertion that was presented to the trial court, or is that in the complaint only?
There isn't any depositions that was presented, and that would have been an oral representation from the defendant to REDSHIFT, to the manager of REDSHIFT. So there's no evidence.
There's no evidence of that. That right now is an allegation in the complaint.
It's just an allegation, and again, we're trying to amend, as you know, we're trying to amend the complaint to include a fraud count, because it's either you breached the contract or you committed fraud in the execution of the contract. And that's why we wanted to,
if that allegation is true.
If that allegation is true, right? It's absolutely. So it's for us, it's one or the other. You either have a contract that you didn't perform, or you committed fraud and misrepresentation in connection with the lead up and performance of that.
Can I just? I'm still trying to get my head around your view about the idea that even on the facts as we know them now, your client is entitled to specific performance, which means I think you think that the Superior Court Civil Division judge should issue an order saying, this property is hereby sold to REDSHIFT for the contract price. That seems to me disturbing as to the interests of the other heirs. Here, so take the other heirs. They are not party to this contract. They have nothing to do with it. They have an 87% interest in this property. There's an assertion that, the actual value of the property is 2 or 3 times what the contract price is. The effect of specific performance would be to, I guess, divest them of their interest in that property because of a contract entered into by some other person. How could that? I have a hard time understanding how that could possibly be equitable or appropriate. Can you explain to me how that is fair relative to the interests of the people holding the other 87.5% interest in this property?
There's a couple of responses to that. Number one, keep in mind this property was in tax sale that had advanced fairly well in the proceeding, and they were about to lose the property, so it would have been zero interest in proceeds to any of the other heirs if someone didn't take action.
I'm sorry, what action did you take to prevent that from happening?
To get appointed as PR and sell the property.
No, I'm sorry.
Well, nobody did that, and it wasn't sold, right?
Yeah, ultimately, it was redeemed. Ultimately, someone in the family redeemed the tax sale. But my point is someone would have had to do something, whether that, and typically in tax sale, my experience, tax sales, you have to sell the property, right? Because people aren't going to redeem it. You're going to have to sell it and get whatever equity they can get. And there's an email even in the documents that are included in the transcript that specifies that. I mean, Ms. Shaw actually says, yeah, hey, look, I know this property is worth more, but reality is, I just don't want to deal with it, and it's going to tax sale, so that's why I'm working with you, Mr.
No, I get how it might be equitable as to Ms. Shaw. If you accept the factual representation, she could have made a judgment that relative to her interests, accepting a below value cash payment would be better than trying to redeem the property or whatever else. What I'm, again, struggling with is how that could be equitable as to the interest of the 87.5% interest holders who weren't consulted about that judgment, had nothing to do with it.
Because somebody has to get appointed PR, and that person acts for the rest of the estate. They don't need to obtain consent from the rest of the heirs.
No, but they need to act, if they are the PR, they need to act as fiduciary.
They don't need to obtain consent.
I understand that, but they need to act as a fiduciary. And you agree, you don't think Ms. Shaw was acting as a fiduciary or required to act as a fiduciary when she signed the contract at issue, or do you?
I think that's a tricky question. She wasn't appointed as personal representative at that time, and so in that sense was not acting as a fiduciary, but she was obligating herself to go open up the probate estate and sell the property.
Okay, do you want to take a moment to talk about your amendment issue? And let me tee it up for you real quick. The problem I see with your appeal of the denial of the motion to amend the complaint is that none of the reasons you articulate in your brief are articulated in your motion to amend the complaint. What you say in your motion to amend the complaint is, we've got all the facts necessary for fraud and misrepresentation have been developed. We're ready to go ahead. When there's obviously a whole universe of facts. Both you, but if you wanted to waive your right, that's your right. But Ms. Shaw might want to get into to develop a record on the fraud and misrepresentation claims, right? I mean, they would have a right to figure out what you guys knew before entering into that contract, what you reasonably should have known about other heirs, because that would go to your reliance on any misrepresentation.
And we certainly would have had no objection if there was an extension of discovery granted, as it's
right. But my point is that your motion to amend said none of that's necessary. The reason why you should allow us to amend this complaint is because we can proceed on what we've got, and that's end of story. When it doesn't, and the trial court's response seemed to be, well, that's not the end of story at all. It took you over a year to amend this complaint. You say you always had the facts necessary to develop it. You don't give us a reason why you didn't assert it a year earlier. And now you kind of conjure up some reasons. You say late-breaking discovery, but those weren't in your motion to amend the complaint.
So we just received in May of 2018, a week before we filed that amendment, motion to amend, finally, after asking for it for many, many, many months and even years, the information about the family genealogy.
That's something you might have wanted to tell the trial court. That's not in your motion to amend, though, is it?
I would not. I'd have to reference the motion to amend, but
you don't give any explanation for why. I mean, and this was the trial court's finding: is there's one paragraph that consists of 4 sentences, pretty cursory, that explain your reason why leave should be granted to amend a complaint filed more than a year after the original complaint. And the gist of it is, there's no new facts to develop here. It's all the same stuff that we've already developed. End of story. There's no, we found out new stuff. There's no, we couldn't have alleged this a year ago. There's none of that. So, I mean, I have a hard time faulting the trial court for looking at this motion to amend and say, I don't see any justification for it.
Okay. I mean, I personally, I think we satisfy the 5 factors in Taylor. I don't have certainly it's routine to grant extensions of discovery. We wouldn't have objected in that regard. If there had been an oral hearing in this, we would have articulated and been able to field these sort of questions.
If an amendment, so let me just try to tee it up one more time. An amendment that comes more than a year later, that the assertion is we had all the facts necessary for this claim a year ago. And I understand that's not what you're saying now, but that's what the amended complaint says. It says the cause of action for fraud and intentional misrepresentation, I'm quoting, are based on the same facts as the breach of contract claim are currently pending before the court. So not only do you not assert newly discovered evidence, you seem to say we've always had this. And so why did you wait a year? Well, there's no explanation. On that record, I would think a trial court could deny motion to leave to amend, at least within its discretionary judgment.
Okay, I mean, I understand your point. I don't think that's what we intended. That interpretation is not what we intended with, all the facts are here. What we're saying is the parties are still the same. The underlying chronology, i.e. facts, is what it is. And we just discovered, and I understand your point. That wasn't perhaps expressed in a robust fashion. But my understanding and impression is that courts routinely grant motions to amend a complaint, particularly when more facts are discovered in discovery, and that's been my experience.
They may, but you may run your risk if you just file a pro forma motion that doesn't give you your grounds, and the trial court isn't inclined, and then you go to the Court of Appeals. You may run the risk of not having made an adequate record in the trial court. Can I ask you just more on the merits, because your opponent argues, I know we're a little over time, but your opponent argues that actually, if we get into the weeds of what you knew when, that there's a lot of reason to believe that you knew or should have known that Ms. Shaw was not the sole heir long before you filed your motion to amend the complaint. And they point to participation in the tax sale litigation. They point, I think, to some comment about you speaking to family member, some evidence that you spoke to the family. And that's part of why it's important for you, if you were trying to say part of the reason we need to amend and part of the reason we're filing now is we know new things and there's a factual dispute about, well, did you really know or not know? If that is raised in front of the trial court and the trial court says, oh, there seems to be a dispute about that, I don't know whether I should or shouldn't amend. Let's try to learn and let me try to make determinations about all that. That can all get sorted out in the trial court, but it's a little harder for us to resolve those uncertainties. But can you, if you want to take a sentence or two to explain why none of your prior involvement and nothing that would reasonably have been expected of your client in connection with entering into the contract or engaging in the litigation would have put you on notice that Ms. Shaw's representations about being the sole heir, which you claim to have taken place, were false. What's your response to the idea that, well, actually there was much you could have done and many indications to you that you could have explored that if she did represent that she was the sole heir, that just wasn't true? What's your response to your opponent's argument on that?
Yeah, I mean, I take significant umbrage with that issue. Number one, I mean, it's just not true. So the tax sale, I take each thing in succession, if you like. The tax sale, we intervened. The court, it's a routine matter in tax sale proceedings to have the tax sale certificate holder conduct an error search. That's all that was said. There's no.
No, and the point is, if that's a routine thing to do. If you are engaged in tax sale litigation, your opponent's argument, I think, might be, it would be equally routine to expect that you would do that if you were, engaging in a contract, or in any event, once you start up litigation and you're suing the person, find out if it's true. You might have a fraud claim if they're not the sole heir, which, the tax litigation points to the routine aspect of figuring that out. Why wouldn't it be an ordinary part of your diligence in filing the lawsuit to determine whether there were heirs, other heirs besides her, if you claim she was falsely asserting that she was the sole heir?
Because there was reasonable grounds to believe that she was probably right. The tax assessment itself lists her as the owner. It lists Ida Bowling and LaVonne Shaw, and Ida Bowling was dead. So my client is not a lawyer. My client, had a contract. Let's just assume the allegations are true.
No, but once you filed your lawsuit, your client was represented by a lawyer.
That's true. But remember, our legal theory was this should be specific performance. This individual can open up a probate estate. She's got all the cards. We don't know who's died in the past. We don't know the family relationships at all. All we have is a contract, and we're suing on the contract. Part of the contract is, again, what we talked about, obligation to provide clear title.
We're talking about a different question now. We're talking about when you should have filed a motion to amend to add fraud and misrepresentation claims, and looking at her November 10th, 2017 affidavit, line 3 says, there might be other heirs out there. Now that would seem to put you on notice if you had a fraud claim.
Again, we only got information about exactly what the death dates and the other heirs were, the genealogy of the family in May of 2018. And it took us 1 week to file an amended complaint after we actually figured that out.
You're still on mute, Judge Beckwith.
Thank you, Judge Deal. Thank you, Mr. Gormley. We will give you a couple of minutes on rebuttal, and we'll hear from Mr. Henry.
Morning, Your Honors. I'm Bobby Henry, and I represent Ms. LaVonne Shaw. I'm going to rearrange my argument here based upon the dialogue that has gone on thus far. And I want to start by simply going directly back to the last point about Ms. Shaw and what the plaintiffs knew and when they should have known it. Your Honor, I believe that was Judge Dahl referred to her affidavit that was filed. You can go back a month prior to that in the answer and the counterclaim to the complaint. And if you look in there on the very second question, there was an allegation that Ms. Shaw was in fact the only surviving, was the only heir to the estate. She categorically refuted that. She said that I'm not.
I'm sorry, where is that?
She outright denied it. And that was in October.
Mr. Henry, can you just give me a
Yes.
citation for that? What are you looking
Oh,
at?
I'm sorry, Your Honor. Begging the court's indulgence 1 moment now.
I mean, are you talking about the request for admissions where you guys basically just denied everything because you disputed what the...
No, Your Honor,
Or are you
the
talking
answer
about the answer?
complaint. We filed an answer to the complaint and begging the court's indulgence. I'm sorry.
I don't, I'll look for it while you can continue and I'll look for it. I don't want to slow you down.
Okay, our answer, Your Honor, was filed on, I'm just trying to find oh, you want the citation. I'm sorry, Your Honor. It's in the appendix, the supplemental appendix.
Right.
At 46.
Got it.
In paragraph 2. And we answer, and they answered that, Your Honor, based on his complaint. I also want to return to another point that the court brought out, and that Mr. Gormley continues to this very day to still suggest, and that is that Ms. LaVonne Shaw has the highest of priorities. I will suggest for the court that she does not have the highest priority. There are 3 surviving granddaughters. How do you pick one granddaughter over the other granddaughter and say?
Counsel, I'm not sure why this matters. If Mr. Gormley is correct that having signed the contract, your client had an obligation to do whatever was in her power to become personal representative of the state, and she didn't do anything. So, you might be right that there are other people that had some priority, but what's wrong with the argument that your client should have tried?
Well, Your Honor, the contract actually, as the court accurately found, that the contract was not a binding contract on Ms. LaVonne Shaw. that.
Yeah, but when it said that, it said it for reasons that are a little bit, I think, inaccurate if taken at face value. For the reasons cited in the cases that Mr. Gormley cites to, which is the trial court seemed to say because she was not personal representative at that time, she couldn't perform the contract and she lacked capacity, therefore making it null and void. But there are cases, too, from Mr. Gormley's brief, where the person was not the personal representative at that time, and the court said it's still an enforceable contract. They had the obligation to go become personal representative and carry through the contractual obligations. So, I mean, it seems like a little bit of a misstep in the trial court's reasoning there.
Not so, Your Honor. I would respectfully beg to disagree on that. And that is, this case is completely distinguishable from both the DSP Ventures case as well as the Lyle case, because as in there, all of the potential heirs with a distribution that would come to them all agreed, or everybody agreed on it. And if the court would take a look at the probate court rules under 112B, there is a similar requirement, not a requirement, but there is something similar there, that if all the heirs that are involved and have a distributable share, if they all file a written agreement, the court would then move on their matter.
I absolutely agree.
But they would have to consent. But what we're saying here is that Ms. Shaw and the parties here, this is exactly what the law seeks to prevent, and that is a non-judicial distribution of assets.
Counsel, if I can interrupt you just for a second.
Yes, Your Honor.
I agree that is quite a convincing distinction of Douglas v. Lyles and the other case. The name I always forget, DS, some initials. Doesn't seem to be the one that the trial court articulated, though. So when reviewing the trial court's judgment, I wonder how much we can lean on that distinction, where the trial court seemed to say somebody who could become personal representative, if they're not personal representative yet, lacks the capacity to enter into a contract. That legal conclusion seems to be squarely foreclosed by Douglas v. Lyles and the other case relied upon by Mr. Gormley. So I'm wondering how much of this theory that all the heirs needed to be a party to it, which I think is a quite persuasive distinction of those two cases, I just wonder if it factored into the trial court's reasoning at all.
Yeah, yes, it did, Your Honor. And the Douglas v. Lyle, the DSP case, those are exceptions, Your Honor. Those are not the rules. More specifically, the trial court looked at each and every line of the particular contract. And it looked at it to determine whether or not it met the prerequisites. It met the prerequisites for a particular transfer of property according to it's called under the old law, the pre-1995, well, the pre-July 1st, 1995 law, which Miss Shaw's grandmother, she passed away on March the 18th of 1995. So she clearly came under the old law. And what the trial court did was very meticulously go down each and every line, and they counted each of the paragraphs. And they made a considered decision that this contract, this did not meet the requirement that is necessary for a personal representative. For a personal.
Can I ask you, let me try this another way, because it seemed to me, well, let me ask you a hypothetical. Imagine that Ms. Shaw had been the sole surviving heir. And imagine that this contract was the same as it is. Do you think that the contract would have been void, or do you think that the contract would have been valid and enforceable through specific performance?
If she were the sole heir, the sole beneficiary, as in DSP. DSP was only one heir, so I think that may be akin to your example, Your Honor, because there was only one person there, and because you have 100% of the expectancy of the inheritance, then it would not have made a difference, would be my opinion.
I'm not sure it would not have made a difference. Do you think a contract like that would be void or not void?
Begging the court's indulgence, just one moment, Your Honor, because she was, I don't think that it. Well, first of all, there would have been no one to object to it. Would it have been?
Well, if it's void, she could have objected to it.
Right, same scenario as here. So she's still there. She chooses not to go become personal representative.
If she had the exact same, well, now you come into almost an equity argument, Your Honor, wherein under those facts, it would appear as if the person or the heir is attempting to get out of the particular agreement that they signed, and that they are the only ones, and so they could give full consent. And they in fact gave full consent.
I'm still, I guess, unsure whether you're saying you think it would be legally void or you think it would not be.
I think that it makes a difference that there is 100%.
Okay, so you think it would not be legally void?
The other thing that could happen here, Your Honor,
Counsel, just again, Counsel, I'm trying to get a definitive answer. I'm still working on it. So you say it makes a difference. Does that mean you agree a contract like that would not have been legally void? Or do you think it would have been? Or, I mean, it is an available option to say you're not sure. So, feel free to say you're not sure, but I'm struggling to figure out which among those three things you want to say.
Well, I'm just thinking that through very quickly, and I'm trying to figure out in my mind whether or not we're going to run into an issue of sort of the after acquired property rule here. Because if she did this, what should actually happen is whomever she signed that contract with should then turn and go directly to the probate court. Because under the probate rules, they even would have an interested person, as quote REDSHIFT says that they always had the right to go straight to the probate court and bring up the fact that, hey, this is going on with regards to a contract that we have here, and this is our interest. I believe that would the contract be voidable?
If you're not sure, counsel, I wonder what distinction is in your mind between Douglas and DSP. Don't Douglas and DSP answer that?
The distinction between Douglas and DSP is between the two of them, the only difference is a distinction without a difference, is that one of them had multiple heirs in it. Counsel,
let me just be a little bit clearer. I suppose I'm saying, what is the difference between Judge McLeese's hypothetical, where Ms. Shaw was 100% entitled to 100% of the property, and entered into this contract before being personal representative? What is the difference between that hypothetical scenario that you seem a little reluctant to answer?
I understand.
And Douglas and DSP seem to squarely answer that is not a voidable contract, that is an enforceable contract.
I understand. It would be a voidable contract.
It would
be
not be a voidable contract.
Yeah, it would be a void contract. Yeah. Now I understand what the scenario that you're posing to me now, because you're directing me right back to the actual contract that we have in the matter at bar. You're taking me right back to that contract, and that contract is void. That contract purely is void. But the other point I think you have to take into consideration here is the presumptive interest of the particular heir, and that's something that I don't believe that you could just not taken into consideration. Because if you have 100% of the presumptive heirs agreement, that's significant. But in the case that we have at bar now, we have multiple heirs. We have, as a matter of fact, including Ms. Shaw, we have 4 heirs. And you're absolutely correct. Ms. Shaw only has 12.5%. 12.5%. It would be against the public policy and the exact thing that the law seeks to prohibit, and that is the taking advantage of a third party. As a matter of fact, one thing that the court, and I believe it is in the DSP case, that the trial court ruled that it was not enforceable based on the Riley case. And the Riley case indicated that the husband could not bargain away the wife's dower rights. How I want to sort of bring that to the court's attention is because in the case at bar, what's happening is LaVonne Shaw actually would have bargained away the rights of the other heirs. And there are protections in the law that require a personal representative to, number one, be appointed, to number two, you have to get an appraisal of the property by a licensed DC appraiser, and you have to have a bond. And all of that has to go to the court for review. The reason they do that is to protect those unwitting potential heirs. In the case at bar here, we have someone who just came in to the Shaw family's life 30 days before this contract was thrust upon them. 30 days. And it was about 30 days after the county's case, the foreclosure case, which REDSHIFT knew about. Well, they indicate that they didn't know about that case. They in fact knew about that case. And literally when they did the contract, what they said was, this needs to be closed in 15 days. We have to be real clear and honest here. There's absolutely no way you're getting to 30, you're gonna close, you're gonna get appointed, you're going to get the appraisal done, you're going to get it to the judge, and you're gonna get bonded, and the judge is gonna approve all that.
Can I ask, and I'm sorry, I know we're taking over your time a little, but I have a question, because that all seems to go to the question of whether or not this contract envisioned Ms. Shaw going to become personal representative, or whether it was instead a non-judicial sale of an estate property. But I think what Mr. Gormley would reply with is, you know, immediately after signing that contract, the communications are all about going in to probate and becoming personal representative. So there's a factual question, one that could not be resolved as a matter of law, about whether or not their version of Ms. Shaw needs to go become personal representative, or the trial court's version, which is, no, this assumed some non-judicial sale of the estate. Not so clear to me which of those factual scenarios is correct, and I'm not so sure it was correct to decide that as a matter of law by the trial court. Do you have a response to that?
Yes, I believe that the trial court was absolutely correct. From all the indicators, it appeared as if this was going to be a non-judicial sale. If you look back at the requirements that were placed in that particular contract, it was always set to be that way. The trial court also brought up the fact that they did not conceive of a scenario whereby a savvy investor would go and not do their due diligence as to who is the rightful heir. I mean, it doesn't make sense. This court, as I recall, has a way of looking at I'll strike that. I won't go there, but it deals with reasonable inferences versus just a speculation. And if you look at this, it's not reasonable to speculate that they believe that all of the requirements were going to be met in 15 days. It's just absolutely not believable.
Thank you. Oh, I didn't mean to interrupt your last sentence, but we've given you lots of time, Mr. Henry.
Your Honor, if I might just take maybe 30 to 40 seconds, because at the very outset, I wanted to let the court know that the court should affirm this decision to grant summary judgment because there was no genuine issue of fact as to any material facts, and Ms. Shaw is entitled to judgment as a matter of law. The court's decision to amend should also be affirmed because there was no manifest error amounting to abuse. The widespread discretion, I'm sorry, I couldn't get that out. The widespread discretion that the trial court has with this particular issue, Your Honor.
Okay, thank you very much, Mr. Henry. And Mr. Gormley, since we've taken you over your time and Mr. Henry over your time, we'll give you the time that you requested, which I believe was 5 minutes.
Yes, thank you, Your Honor. Just very quickly, wanted to touch on, and I can do this rapid fire, a couple of the points that have just been made. First of all, highest in terms of priority under 20-303, it's called as a class. It doesn't, if you have 3 granddaughters, any one of them can petition. That class is given the highest priority. It's not any one individual. There's no conflict that's created as a result of having multiple people in a class in order to qualify for a personal representative. In terms of the point about the trial court considering the Douglas v. Lyles case and the actual logic that's in there, I don't read it that way. The opinion, I mean, I'm citing to the appendix 145 where it talks about impossibility of performance and so on, which is clearly not the case in here. It's clearly possible that LaVonne Shaw could have taken probate paperwork over to the probate division, reopened up the estate, and sold this property. So I don't.
Counsel, I have to say, I kind of hope it is impossible that she would have been able to sell this property through probate at this price, pursuant to this contract, because she has a 12% interest in it. And, you know, what would have had to happen, I would have hoped, is that if it went to probate, the probate judge would bring the other heirs in, they'd do an appraisal, they'd figure it out. And maybe if the contract sale was as good as an appraised sale, then it all could have happened. But if not, then not. So I think well, I don't know if you dispute that the appraised value of the property is substantially greater than the contract price, but if you don't dispute that, then I would hope it would be impossible that this could have been achieved through probate.
Well, I think there's a couple of things. Number one, the appraised value keep in mind it was 4 years ago that the value of the property was not 2020, not 2018 when this litigation was going on, 2016 when they entered into the contract, and the property is in a shambles. It's a complete dump. And so I think, yes, the appraised value could certainly have come in that low. Also, I've personally have had many cases where all the heirs just sign off and consent, and there's no requirement for appraisal or for a bond. So that is quite common, and we do try to do that to save the estate some money. Given the fact that this was in tax sale and the latter stages of tax sale, I would have thought there would be a great incentive for the heirs to go ahead and sign off, or for the court or appraiser to say, hey, yeah, the value really is this, because the only way you're going to sell to is someone in this sort of position who can close pretty quickly and beat the tax sale. Can
I ask you a question, though? I know I'm interrupting your rapid fire point, so I want to get you back to it. But I just have a question about diligence and your client. I mean, if you were representing a corporate, a real estate investor, and the real estate investor said, I'm speaking to somebody who is willing to sell some property, and she tells me she's the sole heir. And here's the contract. I'd give him $5,000 earnest money up front and various other things. If you were advising your client, would you say, yeah, go ahead. That's fine. We don't need to do any inquiry into whether the person who claims to be the sole heir is the sole heir? Or would you advise your client, well, we need to actually try to, can she prove that she's the sole heir, or can we investigate that? But before you sign a contract with someone who purports to be the sole heir, would you advise your client to do some due diligence? I don't mean your particular client here. I just mean in general. Let me put it this way, rather than you personally. Would a reasonable lawyer advise a client to do some due diligence about before signing a contract in that way.
No one does that. You rely on the seller's representations. The seller has the obligation to provide marketable title. And if they're providing a representation that says,
well, that's true. I mean, that's true as leave aside when you're in the context of a decedent. If someone comes in and says, yeah, I own this property, I'm going to sell it. I thought everybody did do a title search.
That's right.
They don't just rely on the representations and say, oh yeah, the seller says that the seller's going to provide marketable title, so I'm not going to really do a title search. So people don't rely on those representations. I understand they may be different. My only point is people don't rely on those representations always.
They do for purposes of signing a contract. The distinction is with a title search. Everyone gets a title search in order to ensure that there's marketable title. So those are two very different things, I think.
I see. Your view is you would sign the contract and then title search would identify the problems thereafter.
Exactly.
Got it. Thank you. Got it.
Okay. All right. And that was actually one of my points, that the onus really is on the seller here, in this case, LaVonne Shaw, to provide the accurate representations as well as marketable title, which would include, of course, reopening up of the probate estate, that the buyer's not obligated to do any extra due diligence on that score. I would point out that the original Ida Bowling estate was opened in 1995, and no personal representative has done anything with respect to the property in all of that time. Any of these other heirs could have taken—
Well, counsel, I think that's not right. If you're talking, I thought there is activity going on now. I mean, there was later a personal representative appointed, and then now there's activity going on in the probate matter. So there came a time when a personal representative got involved in doing things, right?
2 years after we started litigation.
Understood.
Extreme bad faith. I mean, that's purely a litigation tactic. That's not an accurate depiction. What I'm saying is, between 1995 and 2016, when the contract was signed, no action was taken, and any of these other heirs representing the 87.5% that you guys are keyed in on took any action during that time, and they could have. Any of them could have, and no one did. So it's not reasonable, I think, to bank on the fact that she had a minority. Any heir with a substantial, with a priority interest, and even without a priority interest, you can go standard probate if you want, and because no one's taking any action, can open up a probate estate, and that's what Ms. Shaw did, which should have done pursuant to the terms of the contract. So I don't think it's dispositive to say, oh, well, she only has 12.5%. Well, she's got priority. She can do what she wants. If obviously, if the court has to open up the estate and go through the motion.
Well, no, she can do what she wants, subject to her obligations as a fiduciary and subject to the approval of the trial court.
Correct. What I say, do what you want to, I'm sorry, that was loose language. What I was trying to say is she can go and file a petition in the probate court to open up an estate if she wants. That's what I'm sorry for the inarticulate expression there.
Let me just ask about a sentence in your reply brief. I want to understand the import of this. You said that after you learned about the other heirs, REDSHIFT, and this is at page 10 of your reply brief, REDSHIFT quickly realized that its original legal theory of purchasing either the property itself or Shaw's inheritance expectancy interest became moot. And I wonder what impact that has on your appeal of the trial court's resolution of the contract claim. It seems to be saying to me, seems to be a bit of an admission that specific performance is not available.
No.
In what other sense is your principal legal theory moot?
Because the original contract contemplated an assignment of an inheritance expectancy, and under the original theory, Ms. Shaw had 100% ownership of the estate, right? Of the benefit.
Well, I mean, just to reread the language, its original legal theory of purchasing either the property or Shaw's inheritance expectancy became moot. So to lop out a phrase, its theory of purchasing the property became moot. I'm taking you're saying now that was just a misstatement?
Right. We're referring to the inheritance expectancy. We thought if she was 100% owner, we could get an inheritance expectancy transfer, right? If she's
I understand.
12.5%, that's moot. We don't want to buy a property for 12.5%.
That part I understand. I'm just saying that there's a different sentence that said the theory of purchasing the property was moot. That's what the reply brief says, and if it's inadvertent, that's fine. Inadvertent,
yeah, that's what we're referring to. Okay. The only other, there's two other points. One I was going to refer to, and that is the Riley case. Mr. Henry referred to the Riley case that was cited in the Douglas v. Lyles case. That's the one with a spouse. It's an old 1923 case where a husband, they held a husband can't sell on behalf of the spouse's dower interest. that case is specifically distinguished in Douglas v. Lyles as saying, hey, wait a second. Yes, that's true. The husband can't speak for the spouse. The spouse has a dower interest and would have to sign the contract. That's exactly not what we have here, as was the case in Douglas v. Lyles. We need one person to sign up as personal representative. Ms. Shaw could have done that, and then she would have had authority to sell this property. So the discussion about the dower is actually.
So that prompts. I'm sorry to interrupt, but that does prompt a question. Are you saying that you think that if you had known ahead of time, and if let's say Ms. Shaw had said, I have a 12.5% interest in this property, but I am the personal representative. I have the highest priority to be personal representative. And so I'm going to enter into a contract where I'm going to sell it to you. I only have a 12.5% interest, but here's what's going to happen. I'm going to go and I'm going to be appointed personal representative, and then I'm going to sell it pursuant to this contract inside probate. You're saying that is if that had been the contract, you could get specific performance even if you had known that it was she had only a 12.5% interest. Is that right?
Yes, and I will tell you that happens all the time. As you know, the DC real estate market is very competitive, and investors contact heirs in foreclosure cases, in probate cases, and so on. And they indicate to heirs, hey, look, I'd like to buy this property and give you guys, some money.
I get it with collective heirs for sure. If it really is happening all the time that you go in and that a real estate investment company finds an heir who has a partial interest in property but would have priority as a personal representative, and it enters into a contract where that person purports to agree to sell the property in toto because it is assumed that that person will be able to navigate the probate aspects of that by getting appointed, by being able to sell the property in probate. If that's happening, it seems to me quite unclear that that's a valid way of approaching things. And it does suggest that if we disagree with the idea that that's okay, we should be publishing an opinion about it if that's a common practice.
Someone has to contact these heirs, right? If it's a tax sale or it's a probate and the property is wasting away. I think what happens is people contact the heirs, as many as they can. This is just anecdotal, right? This is not with respect to the specific case per se, but just anecdotally. And someone has to step up to become personal representative because it's clearly established only the personal representative can sign the deed. That's undisputed. It's not a non-judicial sale, contrary to Mr. Henry's claims. Everyone understood that a personal representative had to be appointed. There's no dispute about that. So someone has to do it, and so heirs will be contacted, and whoever steps up to the plate typically gets appointed as personal representative, and then signs a deed and transfers the property. So I mean, that's how it works as a practical matter.
I think this was your penultimate point, so I want to make sure you get a quick shot at your ultimate point.
Yeah, I think just stepping back, I would say let's think about the risk of loss here and the public policy arguments. To me, I think the risk of loss should be borne by the person signing the contract, i.e. the seller, the one who's making the representations that they can sell the property. Remember, this is a contract. It's signed by two parties. It has mutual obligations. The seller side is saying, I promise to sell this property to you, the counterparty, under the contract. If they decide that they can't do that or don't want to do that, then the risk of loss really should be on them.
That would be a pretty reasonable argument if there weren't other heirs who had an 87.5% interest in the property who weren't party to the contract. If there is a loss, why should they bear any risk of that loss?
Because they could have stepped up in the intervening 20 years and done something, and they refused to do it and let the property go to tax sale. So any heir can, as a matter of statutory law, step up and open up a probate estate, especially the one that has the highest priority, or is in the class of people with the highest priority.
But if they fail to, they can also object to a sale of real property in probate.
They could have, in theory, they could have.
And a judge might independently, absent an objection, say no good.
And then presumably we would have contractual money damages, a claim for a breach of contract with our counterparty.
Well, maybe, especially, but you'd expect the contract to look something like Ms. Shaw shall become personal representative of this state she shall seek court approval for the sale. You wouldn't expect it to look quite like this one, which really does look like a non-judicial sale.
So I don't think that that's quite right. Buyers are not going to be savvy to the genealogy, the dates of death, all of the requirements. And I mean, these are non-representative.
Nothing I said required any of that. Everything I just said Ms. Shaw shall do what you can to become personal representative of the state.
But that's a legal conclusion.
I'll sign on to the sale.
No, but I think that's a legal conclusion that would require more sophistication on the part of a buyer to understand and know that, hey, this is what is needed, and buyers don't.
Well, you're saying your client, you're saying the whole understanding was that you knew that was needed, and that was the plan all along. So whatever may be true of other buyers, that doesn't necessarily suggest any unfairness relative to your client.
It's part of the clearing of marketable title, providing marketable title. That's in the contract. It says that the seller has to provide marketable title. That's what our contract says. Part and parcel of marketable title, according to the Douglas v. Lyles case, is opening up a probate. That's black letter law now. It's very clear. That's part of marketable title. That's what title companies do. They review.
But it's something that is not in her power to do, counsel. I mean, it is something that she was at the. It could have been objected to. A court could have denied it. So it's something that was not within her power to do in the way that it might have been if all the heirs had signed.
It was within her power to do because she had the highest priority. All she had to do was march.
She could have become personal representative. Maybe I'll grant you the legal point. I'm not sure if it's right, but that doesn't mean that she gets to go forward with the sale when a court could always say no.
But she didn't even try.
I understood.
And the reason why she didn't try is because she was gaming the system and trying to resell for a higher price.
Thank you, Mr. Gormley. And thank you both for your briefs and your argument today, and we will take this case under advisement.
Thank you so much for your time.
Thank you.
Mr. Henry, I think you have a smoke detector that needs a new battery. Just want you to stay safe over there. I'm sorry, you're on mute.
You're on mute.
I heard beeping that I thought was only coming from you.
Oh, I'm sorry. Yeah, no, I was muted. I'm sorry, Your Honor.
Okay, judges, we're bringing the next case.
Okay.
Counsel, you
Thank
can
you, Your
next.
Honor.
Thank you.
Good morning, or afternoon, still morning.
Good morning.
This is Ed Gonzalez. I represent the appellee.
Thank you, Mr. Gonzalez and Mr. Adams. You all set there? I will call the case. The third case this morning is number 19 CV 479 and 19 CV 562, which are both titled Robert Charles Doheny versus Medical Faculty Associates. Hopefully I pronounced that right. See, Mr. Adams, you can go whenever you're ready. Can you hear us, Mr. Adams? Maybe not. Can't hear you.
Counsel, if you can log out and log back in.
I forgot to give my spiel at the beginning about being patient.
I think COVID-19 has taught us all a lot about being patient.
Yeah.
Okay, counsel, do you have a cell phone? Is something wrong with your internet or with your device? If there's a way you can use a mobile phone that has video and audio, then I'll let you in there.
We have a mobile phone with a video and audio.
Now we hear you.
Okay, we hear you now.
Can you hear us, Your Honor?
Yes.
Yes,
Okay,
Thank you.
sorry for the inconvenience.
thank you. Whenever you're ready, Mr. Adams.
Very nice, thank you. Hey, please, the court, my name is Robert Adams. I represent the appellant in this case, Robert Doheny. This appeal is taken from a grant of a motion for summary judgment by the trial court. It's a medical malpractice case, and it's a relatively factually simple case as these things go. I think you'll agree. The history of the case is this. On January 30th and February 12th, 2014, the appellant's wife, Joyce Doheny, underwent cardiac surgery at the GWU Medical Center in the nature of a radio frequency catheter ablation. This particular procedure was performed by Scott Shapiro, who's a cardiologist and electrophysiologist employed by the Applee Medical Faculty Associates. One of the known risks and potential complications of this procedure, which is a potentially fatal problem, is the development of an atrioesophageal fistula, which is a hole between the left atrium of the patient and the esophagus.
Mr. Adams, I think you can assume that we're all familiar with the facts, and since your time is limited, I wonder if you would jump to the issues you would like us to think about.
Sure, Your Honor. As you know, the grant of summary judgment was on the defendant's motion for summary judgment, alleging that no duty was owed by Dr. Shapiro to Mrs. Doheny in the circumstances presented. We obviously take a great deal of umbrage with that because this man here performed two major invasive cardiac surgeries on this woman.
Can I ask, just, is your theory that he owed a duty of care as her treating physician or as a consultant to ANOVA?
No, our position is that he was her physician for anything related to that surgery and follow-up care. He'd seen her 2 weeks or so before as a post-op visit. We're not saying that he should have jumped in and taken over from Dr. Donani or recommended or ordered them. That was the province of the people who were seeing her at ANOVA. What we are saying, and what our electrophysiologist experts are saying, that the duty he had to her in Dr. Gonzalez's alleged we're conflating the two. We actually are conflating. He had a duty to his patient, and she was still his patient, to have informed Dr. Donani of the existence of an AEF, which nobody knows about, electrophysiologists.
Is that duty just sort of indefinite, or does it sort of become revived when it's actually important for Dr. Shapiro to do something with respect to his treatment of her?
No, I don't think Dr. Shapiro had any responsibility for treating her. She was in the care of competent people at ANOVA. What his obligation was within the standard of care was to inform this intensivist who knew nothing about this condition, wouldn't have been expected to know anything about it, of the fact that such a thing existed, that it was a known serious complication of the.
Can I ask you, counsel, again about how far it lasts, the duty that you believe exists? So, I mean, imagine that what had happened was that this complication had emerged, I don't know, 15 years after the procedure. And imagine that the emergency room doctor had called Dr. Shapiro, and Dr. Shapiro had said, you know, I don't remember much about it. I'm retired now, and I really, can't help you. Are you saying that he had a duty, he would have had a duty, and therefore those answers would have been, assuming that was negligent, and he should, are you saying that he would have had a duty then, or he might not have, or how do we figure out how long it lasts? Well,
I don't think he would have. I think the nature of the condition, which we're familiar with because we've been in this case, it's basically generally a thermal burn.
No, my question is more abstract. I don't want to tie it to what's likely complications and when it might have arisen. So be more abstract. Imagine that a surgeon performs a procedure that can have complications 15 or 20 years down the road. And that surgeon gets called by an emergency room doctor who says, I've got this patient here, and she says that she was operated on by you 15 years ago. And I don't know whether this is a complication of that or not. I'm not an expert. And the surgeon says, well, I wish I could help you. I don't really remember this patient, and I've retired now. And so I just don't, I don't feel like I have any obligations anymore. You're gonna have to find someone who has an ongoing responsibility. And if you need to consult an expert about this kind of surgery, I'm not your person. Is that okay, or is that a breach of a duty that is ongoing?
No, I don't think it is, Your Honor. At that point in time, the physician-patient relationship would have expired with regard to that treatment.
And how do we figure out, well, let me ask you a threshold question about that, a framework question, because I don't think your brief was very clear on it. Do you think that the question of whether there was a physician-patient relationship here implicated by this phone call, do you think that is a question of fact for the jury to find, assuming there, a reasonable jury could find either way? Or do you think that's a question of law that the trial judge was really finding its, determining itself once it knew what the historical facts were? Which do you think it is?
I'm not sure. He says it's a matter of law. If it is, then I think he was totally incorrect. The cases he relied upon were inapposite, in my opinion.
Okay, then. But either way, that was my framework question. Thank you for answering it. Assuming whichever it is, how is the decision maker, whether it's a judge or a jury typically, supposed to figure out whether there is an ongoing duty based on a prior surgery, and when there isn't? What are the factors, or what's the test, or how is someone supposed to figure that out? You said 15 years too long. A month, if I remember correctly, not too long. Is it purely temporal? Does it matter? Are there other variables that would be taken into account? What's the?
I think it's like any case. You have a set of facts. You have a time reference within the time period the facts took place, and the jury's asked to listen to the experts and make a decision based on the case that's before them.
Okay, let me ask you another hypothetical. Imagine that I am a surgeon, and I don't. Really, all I like to do is operate, and I don't do follow-up. What I do, and I say this to my patients up front. Someone else is going to meet with you at the front end, and I'm going to rely on what they tell me. And someone else is going to, deal with any complications at the back end. I'm really good with a needle and thread, or a laser, or a heat catheter. And so I'm your doctor if you want to have somebody standing in the operating theater taking care of you. But I'm not your doctor for before or after. Can a doctor say that, or and if so, is there no duty?
Could a doctor say? I guess you can say anything. I don't think it would happen in real life, but probably not if the patient understood that was the extent of the physician-patient relationship.
So the understanding of the patient is another relevant variable, perhaps, besides just time.
Well, it could be in some circumstances. I don't think that it is here, given the temporality of the events.
And so I'm having a hard time not letting this question of duty of care lead into the question of standard of care. It sounds like one way to think about it is, well, would a reasonable doctor in that position still feel themselves beholden, obligated to follow-up care? And a few weeks later, you would think so. 15 years later, probably not. So it feels a little factual to me, and it feels like it might be bound up with the question of standard of care. Am I wrong to think of it that way?
No, it absolutely is. The expert testimony in the case would come out, and we took depositions of 4 electrophysiologists, that this doctor has a duty, if you will, to this patient to adhere to the applicable standard of care, which in this case.
So let me push on that a little bit, because what's difficult about that view is we seem to have cases that quite clearly say the duty of care is a question of law for the trial court to answer. And so when we get into all these factual questions about, what the experts say, it seems a little afield of the view that it's a question of law for the trial court to decide.
Well, I'm honestly not sure, but if it is a question of law and the trial court was correct, our position is that it was wrongly decided, that the evidence of a physician-patient relationship is so clear from the facts surrounding this case that in and of itself it's grounds for reversal.
It's certainly clear. It's certainly clear a few weeks prior. But I mean, what do you say to? What's your response to Wilson, the Alabama Supreme Court case again?
Well, those doctors in those two cases had really nothing to do with the patient.
She was the primary care physician. She was the doctor who came to the hospital was his pediatrician.
But I think my recollection of the case, Your Honor, is that the pediatrician happened to be passing through, never did assume responsibility for the patient. Knew the patient.
So what? So Mr. Shapiro happened to answer the phone here. I mean, what if he hadn't?
He answered the phone because Mr. Doheny directed Dr. Nani to him because he was his wife's doctor.
Doesn't seem like the happenstance doesn't seem to be any distinction of Wilson to me. So if you have anything better, I'd love to hear it.
Well, Your Honor, you just performed surgery on this lady. These esophageal fistulas don't develop till 4 or 5 weeks later. That's right.
Can I ask you if, again, I have the same trouble of keeping distinct if they are entirely distinct, the question of the existence of a duty and the question of what the standard of care would be if there is a duty. But imagine that what Dr. Shapiro had said in the phone call was, I'm at home right now. I don't remember this patient. And so I really can't help you. Would you say he had a duty and the issue would be whether that was negligent? Would you say he didn't have a duty because he never really, what would you say about a hypothetical case like that?
Well, it would be hard for me to imagine that a guy that performed this kind of surgery on somebody 4 weeks before wouldn't remember. But assuming he said
well,
that.
Actually, I mean, I don't know what the volumes. So some of the folks who do relatively routine surgery, and this may be extremely not routine, so maybe that is the difference. But you can imagine a surgeon who does, tonsillectomies and does 12 of them a day, and then 4 weeks later somebody calls and says, I have one of your patients in the emergency room, and the doctor says, I'm at home, I don't have records with me, I don't recall that individual patient, really can't help you. Is there a duty there? And then the question will be, is that negligent, or do you think there's not a duty there?
Well, I think there's a duty if the physician is the one who did something that may be causing what's going on with the patient at the time. I think there is a duty.
I'm not quite sure then why there isn't a duty 15 years later. And the issue would just be negligence more. I mean, again, maybe it's more understandable if a doctor 15 years later says, I'm retired and I don't remember much, then maybe your point really about that is that there's a duty. It never ends. You have a duty to respond reasonably to any inquiry about a patient you treated that relates to your treatment. And that duty exists forever. And the only issue is, what is your standard of care? That might be true. I don't know. Is that your view or is that not your view?
No, my view is that the circumstances, the doctor can't be held responsible for something that's way far afield that he wouldn't be expected to react to, which is a 15-year later something. But a major potential complication, life-threatening complication from a procedure that this guy just performed on her and told her it was a complication in writing before the procedure, which was appropriate, that it's inconceivable that he wouldn't have, our electrophysiologist saying it's inconceivable, it wouldn't have popped into his head, oh my gracious, this lady may have an AEF and we better do something about it.
Mr. Adams, I think what Judge McLeese was trying to get at is we like rules and we like to understand when something falls within the scope of this doctrine and when something doesn't. And your brief is characterized by kind of a striking or at least a notable absence of case law. Is there more case law out there than what you've given us in the brief? And I don't think you didn't file a reply to Applee's brief, so we're a little bit at a loss.
Your Honor, I did not find any case law directly related to this case. I think this is a sui generis case. It is what it is on its own facts. The cases cited by the trial court and Mr. Gonzalez, I just don't think approach anywhere near the clarity of a physician-patient relationship that exists in this case. Just temporally in the severity of the problem and the severity of the potential problem should have jumped out to Dr. Shapiro, as our people are saying, and they should have jumped through the roof, and if not running down, they should have made damn sure that Dr. Donati had talked to people that are treating this guy.
It's interesting though, what you say Dr. Shapiro should have been keen to did not depend on him being the treating physician at all. It just depended on him having expertise with this procedure, knowing that AEF could happen, and knowing that if somebody presents with a stroke shortly thereafter, AEF is something he might want to alert somebody to. So if this phone call had gone to a total stranger, somebody who had never seen Miss Doheny, would your answer be the same, that that stranger who happened to have an expertise in this area needs to say the correct thing? Hey, if it's a stroke, watch out for AEF. They had this operation a month ago.
In my opinion, there's no physician-patient relationship there. I don't think there is a duty in that.
That answer seems to assume that there can be a duty in negligence only if there is a physician-patient relationship. That's a question we left open. But are you conceding that we should decide, if we were to decide that question, the way we should decide it is to hold that there is no duty that could sound negligence unless there is a physician-patient relationship implicated by the actions of the conduct or inactions of the doctor issue?
I really don't know. I can imagine any number of different scenarios, but that's not what we're dealing with here.
Well, no, your answer to Judge Deal's question was, well, I don't think there would be a duty. And my question is kind of a follow-up, which is, well, that may not be a complete answer if you think that there can be liability and negligence, even if there isn't. I'm sorry, you thought there wouldn't be a physician-patient relationship. And my question was that a complete answer if it's possible that there could be a duty in the absence of a physician-patient relationship? And that, I guess, imagine there is someone who is on call at Inova, who is their specialist, their cardiac surgical specialist, and that's who the ER doctor had called, and it said, I got this emergency room person, was treated by just had this surgery, can't reach the doctor who treated the physician, but I don't want to, make sure I take advantage of your special expertise. Do you have any ideas about how I should be treating this patient, what I should be looking for? You're saying if the Inova doctor had said, well, I've never seen this patient, but I'm being paid by Inova to answer questions like this, and here's my answer to your question, nothing to worry about and no need for a CAT scan. Are you saying no possible malpractice action against that doctor? Or obviously the hospital is an entity you might have an action against for other reasons, but in terms of the doctor himself or herself, do you think there would or wouldn't be an action? And do you think there would or wouldn't be a physician-patient relationship?
I don't think there would be. Let's put it this way, as a practical matter, I wouldn't take the case. You might sue somebody and that doctor be third-partied in by the defendant, but no, I don't think there is a relationship between the two, a direct relationship between the patient and that doctor.
Mr. Adams, can I ask you a question about the record? We don't have a copy of Dr. Shapiro's deposition. And I think it looks to me like it was an exhibit. Maybe it was prepared before the complaint was filed, or can you tell us whether the trial judge had the entire deposition before him, and do you know anything about how, whether it should therefore all of it be before us?
I'm not sure. There actually were two depositions there. He was deposed. I deposed him in the case that was pending in Fairfax County, and then I deposed him again in this case. Mr. Gonzalez may know the answer to that. I'm not sure. Okay. The deposition in this case didn't really address that too much. It was more whether there was potential negligence in the performance of the procedure. It really was more on that. This had already been talked about before.
In prior litigation. Okay, unless my colleagues have additional questions, Mr. Adams will give you a couple minutes of rebuttal, and we'll hear from Mr. Gonsalves. You're on mute. Sorry. I'm sorry, you're still on mute. There you go. But you are off for a second and then you went back on. There you go.
Thank you, Judge Beckwith. Sorry about that.
No problem.
To answer your question first, Judge Beckwith, about the record. It's my understanding that Judge Lopez, the trial judge, had Dr. Doheny's transcript, which in basically 1 or 2 pages addresses the conversation that that doctor had with Dr. Shapiro, and had the deposition transcripts of Dr. Shapiro that were done in the Virginia litigation and the litigation, I'm sorry, the deposition transcript in our litigation. And there was very brief discussion of that conversation in Dr. Shapiro's deposition, because Dr. Shapiro could not recall the conversation, but in Dr. Doheny's transcript and deposition testimony is as what Judge Lopez had mentioned, that Dr. Doheny had recalled that this was a courtesy call to Dr. Shapiro because he had learned from Mr. Doheny that Mr. Doheny's wife had undergone a AV ablation by Dr. Shapiro. So,
Counsel, I mean, it's right to say that there was testimony that it was a courtesy call, but that seems to, that leaves out a component of the call, because the emergency room physician does say that the emergency room physician asked about the details of the procedure and then said, and I did discuss with him that I felt she'd had potential strokes as a result of her atrial fibrillation, and I was asking him if he had any other ideas about it. That seems, at least arguably, as, you know, a request to the treating physician for the treating physician's ideas about what might be going on and what reasonable modes of treatment or examination would be warranted.
that's correct, Your Honor. That is the testimony of Dr. Doheny, who's an intensive care physician. And I want to point out that Dr. Doheny, by the time Dr. Doheny is involved, he's got the full resources of Inova Fairfax Hospital, including cardiology, et cetera. But yes, he did call Dr. Shapiro, and yes, according to his testimony in that Virginia litigation, that is what he said. And I think the important part of that, though, is that enough? I think the question for this court is whether that conversation is enough to extend the responsibility to Dr. Shapiro for the consequences here.
Can I ask you a framework question, the same framework question I asked your opponent, which is, in figuring out whether that's enough, it seems critically important to know whether we're trying to figure out whether that is enough because we're de novo deciding a question of law as the trial court was, or whether instead we're trying to figure out what a reasonable fact finder could conclude. So do you think that the question of whether this call was part of was a component of an act taken as part of a physician-patient relationship, do you think that is a question of law that the trial judge should decide and we should review de novo, or do you think it is a question of fact?
Judge, I think that is a question of law. I think the cases that are cited, not only the Gilbert case, but also the cases cited in the Gilbert case, all assert and recognize that this is a question of law for the court. And yes, it is de novo for this court.
Can I just ask what goes into that question of law? If I'm a trial court, and let's say that Ms. Doheny starts having strokes 2 hours after this operation, he drives to the nearest clinic. Doctor has no idea what's going on and learns that she was just treated by Dr. Shapiro, picks up the phone, gets a hold of him, and says, I don't know what's going on here. Do you have any ideas? Is this going to be anything I should look into? And Dr. Shapiro says, no, I don't have a clue. How does a trial court determine whether or not there's a duty of care? But what are the factors to be considered there?
I think you look at the entire circumstance of the communication or the interaction or undertaking by in this case, by Dr. Shapiro. So
does the fact that Dr. Shapiro has superior expertise than the doctor in that position factor into the equation?
No, Your Honor, it does not. If you look at the case law.
Why not? I mean, you said look at all the facts. What facts and why is that not a relevant fact?
because even if you assume that Dr. Shapiro had gone ahead and told Dr. Donani to order a CT or to do whatever the plaintiff or the appellant is saying in this case, that's not dispositive of whether or not that's a question. Is it a factor? His expertise is a factor, but it is certainly not determined.
Can I ask you, just to go back to the framework question, you said you thought that it was a question of law and you relied upon Gilbert. And I just wonder what you make of footnote 10 in Gilbert, where we said, in Hankerson, we said that the existence of a physician-patient relationship is a question of fact. And we cite Hankerson. So that general statement doesn't preclude a grant of summary judgment in appropriate circumstances, however, which means obviously anything that's a question of fact, if no reasonable fact finder could find one or another, you can grant summary judgment. So your answer to my question seems at least inconsistent with that component of Gilbert. Do you have a response to that?
I do, Your Honor. I think if you look at Hedgepeth versus Whitman Walker, I think Judge Ruiz speaks to, what constitutes duty and what constitutes duty.
Well, just to be very clear, and that's I asked the question about whether there is a physician-patient relationship. That is highly relevant to whether there is a duty. It may, we've left open exactly how relevant in some ways, but it is not exactly the same question as whether there is a duty. And so cases, including other language in Gilbert, that say whether there is a legal duty is, whether there's a legal duty is a question of law, don't necessarily address the exact question I was asking, which is, what about the existence of a physician-patient relationship? There we do seem to have said at least twice that that's a question of fact.
Well, sure. And I think we need to distinguish the patient-physician relationship in the context of the patient-physician relationship. So yes, Dr. Shapiro was this patient's physician and did perform this procedure on her. But when that patient presents to Inova ER and gets subsequently admitted to the intensive care unit and is seen by doctors there, Dr. Shapiro is not a treating physician for the care and treatment that patient is receiving at Inova. And so I think you have to separate out the context. Dr. Shapiro performed a procedure.
Let me ask
the patient.
Counsel, if I can ask.
That was it. So, and I think going back to Judge, I'm sorry.
It's okay. You're breaking up a little, so I think there's a lag, which might be why we're not hearing each other. So just, I'll take a brief pause. But I'm going to look at footnote 6 in the accompanying text of Gilbert, where the court said, we assume without deciding that Dr. Miodovnik, apologies to him, had a duty to use reasonable care when conferring with the nurse midwives. And there's no evidence that he gave bad advice or failed to identify any material risks. That seemed to be a critical part of our disposition in that case. In this case, that is the exact allegation, that Dr. Shapiro failed to apprise the treating physicians of material risks of which he was uniquely aware.
But, Your Honor, if you can hear me, I don't think, first of all, Dr. Shapiro is uniquely aware of that.
As between the two potential treating physicians, he was, that is the evidence, or there's at least enough evidence to infer that he was the only one of the two doctors in that conversation who was keen to AEF being a potential cause of strokes.
Right. In the context of that, that's just a conversation between one doctor to another. We don't know where Dr. Shapiro was when he got the call. There's no information, no data, no scientific evidence or data that is being exchanged between the hospital and Dr. Shapiro. We don't know anything other than the fact that Ms. Doheny was admitted to the intensive care unit and with stroke-like symptoms. For whatever reason, that was occurring at that point in time. Dr. Donani never followed up with Dr. Shapiro. That there was no exchange.
Can I ask you, counsel, I'm sorry to interrupt, but can I ask you how much it depends? Your argument depends here on there being kind of an omission. Imagine that what had happened here instead was that in response to the apparent, in response to what there is evidence was arguably a request by the Inova physician for, suggestions and ideas from Dr. Shapiro. If Dr. Shapiro had said, since you asked, yes, I have a theory about what this is, and I have, here, it's up to you, of course, because I'm not in charge there. You're the one who's on the scene. But what I would recommend is that you do X. And the doctor had gone off and done X, and that was terrible advice, and it affirmatively damaged the patient. Is it your view that there's no duty there and therefore no action against the doctor? Everything else is exactly the same, except the doctor, instead of allegedly failing to mention something that should be done, had recommended something that was done on his recommendation that adversely affected the patient. Same outcome or different outcome?
And I would, same outcome, Your Honor. I said there's no duty under the circumstances of the context of the conversation. And I rely upon.
And can I just say, you raised a
case,
public policy argument towards the end of your brief, and I just wonder whether the public policy points the other way. Why should we immunize, doctors who have previously treated a patient, are asked for their advice about how the patient should be treated, and give bad advice that hurts the patient? Why would you want to have some flat rule that immunizes them from negligence responsibility? It seems like you would want to make sure, you would want to create incentives that people would do that well, and you would want to be remedy the injuries to people who are injured if it wasn't done well. So what's the policy, like the public policy argument about why you wouldn't want to find a legal duty in cases like that?
Because the control is with Dr. Donani and Fairfax Hospital, Inova Fairfax Hospital. It's not with at that point in time, it's not with Dr. Shapiro. And it's a lot like that Newborn versus United States case, which is a Federal Tort Claims Act case, where the doctor in that case, who was at Walter Reed, was giving information, providing information about a sickle cell patient who was admitted to a hospital in Germany. And there was a series of communications and recommendations by the doctor at Walter Reed. And that federal court, the District Court of the District of Columbia held back in 2010, I think it was, that there was no duty by the Walter Reed doctor, despite the instructions or recommendations that he was giving the doctor in Germany, because the doctor in Germany was in control and in charge of the patient. And that doctor, like Dr. Shapiro, had no control or no way to supervise or be involved with the care of the patient at a hospital.
And so it almost sounds as though the point you're making there almost sounds as though it's a flat rule that a merely consulting physician can never be held liable in tort as having a duty to the patient with respect to whom the physician is consulted. So again, assuming that someone who's merely consulting, meaning that the only thing that's going to happen is someone is going to ask for that person's advice, but that person is not in charge, doesn't generally care for the patient. You're just saying that's fatal. I mean, that's a bad choice of term, but it is impossible as a matter of law if all you do is give advice to another doctor about a patient who you aren't otherwise treating and whose treatment you do not control. You can't be held liable in tort because you don't have a duty. Am I right in understanding that that seems to be the logical import of your answer?
No, Your Honor, because I think if you look at the Diggs versus Arizona cardiology case, which I think was cited in the Gilbert case as well, I can't remember, but I know we cited it in our briefs. It might be in the Gilbert case. But that was a case where the ER doctor actually had a cardiologist look at an echocardiogram or an EKG, and that cardiologist looked at the EKG and provided an opinion to the emergency department physician. In that case, that doctor, that cardiologist, had at that point in time undertaken the scope of care.
Well, why is that not true here? If you take the allegation as that there was a request from to your client for his ideas about what was going wrong with this patient, I mean, if your client, it would be one thing if your client said, sorry, I'm too busy, that's not my job. Interesting question whether that would be okay or not, I don't know. But if the allegation is your client, instead of saying it's not my job, just didn't provide any answer to that when a good doctor would have answered, how is that different? If anything, arguably, this case is stronger because your client at one point was the treating physician and did the operation in question. So was kind of consulted, arguably, about his own work and the complications related to his own work.
And my answer to that, Your Honor, is again, going back to the testimony of Dr. Donani in the circumstances of this case. Dr. Donani just says, look, I don't know what's going on here. I don't know what the cause is. I'm going to ask I'm going to ask Shapiro about causes. There's nothing specific about changing the records, looking at a test,
all right, so imagine the conversation had gone as followed. Dr. Shapiro gets
we don't have any of those deep.
We're having a bit of a lag, but imagine the conversation went as follows. The emergency room doctor said, do you have any ideas? And your client had responded by saying, or again, Dr. Shapiro, the entity related to your client, or maybe one of your clients, I'm not sure exactly who you're representing. Imagine that he had said, well, I'm trying to think over the procedure, and here's one thing I'm sure of. I never got anywhere near the esophagus. So although there is this complication called, that can involve damage to the esophagus, and that would call for a CAT scan, I'm quite confident that didn't happen. And so there's no reason to have a CAT scan, don't have a CAT scan. And imagine that the ANOVA physician, in reliance on that, had not done a CAT scan. Is it your view that because he didn't see some additional test, and because he couldn't dictate treatment, that would be, again, no basis for liability because no duty to have that answer be at all accurate? Is that right?
Yes, Your Honor. I would in that circumstances, I would say yes. That's correct.
No duty, no liability.
I don't think
it would
be fair because in this, I don't think it would be fair to Dr. Shapiro.
Completely terrible advice, completely wrong. You say no liability.
We don't know that it's wrong or right. We do know in this particular case.
No, I'm asking you as
in a lot of other cases.
In this hypothetical, I'm saying you would take that view even if it is undisputed that the advice that was the advice that was given and that advice was completely and grossly incompetent. You would say it doesn't matter, no basis for liability because no duty.
I would say yes, Your Honor. I would agree with that. The reason I go back to that is because, again, you're looking at the circumstances of the person who's making the call. So in this case, Dr. Donani or the ER physician or whoever's making the call. What is the capability or resources or the skill of that particular person? Is it a community hospital, for instance, where they don't have the resources of a cardiologist? Well, then that might be a little bit different because then he's actually looking for cardiac consultant advice, right? If you're looking at Nova Fairfax Hospital, where they have cardiologists, they have electrophysiologists, they have all the resources and more that a George Washington University Hospital has. So
well, the ANOVA doctor might well have been
negligent.
The ANOVA doctor might well have been. Sorry for the lag again, but the ANOVA doctor might well have been negligent, I guess, in calling Dr. Shapiro and kind of getting his off-the-cuff reaction rather than getting better input from a better cardiologist at ANOVA. That might well be part, and I don't know that was part of the theory of liability in the lawsuit against ANOVA. So, but I'm not sure that ANOVA could have done better than talking to Dr. Shapiro is a reason to say that there is no possibility that Dr. Shapiro could be liable for what he did once he was contacted or what he didn't do.
I would agree with you, Your Honor, if there was additional communication between ANOVA Fairfax or Dr. Donani or anyone else and Dr. Shapiro regarding the patient's condition as it was developing over time. But there wasn't. This was one call. one call, courtesy call saying, I have your patient here, he should have a stroke. And if you
But, I
believe
mean,
Donani, you know,
Counsel,
what's
I
causing.
think they have proffered expert testimony that will say that says, yeah, even in that instance, a good doctor acting responsibly alerts the calling doctor to the possibility of AEF leading to the stroke. I mean, it sounds like a very factual question to me. It doesn't sound like much of a legal proposition to say, well, he was only on the call for a little bit. And like that doesn't seem like a way to draw a legal line. I think you'd want to know what a reasonable doctor would do in that position. And that to me, again, kind of bleeds into the standard of care question. No?
Well, I think the standard of care question is entirely separate. And we go back to the Wilson case, the Alabama case, where the pediatrician is with the emergency department during the treatment and during the entirety of the treatment and care there on that first ER visit. And that pediatrician is sued, and the Alabama court found that there was no duty because the control of that patient was with the ER physician, not the pediatrician.
Can I ask,
go back to that Alabama case.
My memory in that case, counsel, was that the concurrence noted, and I'm not so sure it's consistent with the majority opinion, but maybe you'll tell me if it is. The concurrence noted, I'm signing on to this majority opinion, but only because there's no indication that the pediatrician gave any bad advice to anybody at the hospital. So again, that would seem to distinguish this case if that concurrence is reflected in the majority's judgment in Wilson. Maybe it's not. But was that a factor in the majority's decision in Wilson? No bad advice was given from the pediatrician?
It's my understanding from reading it that that was not a factor in their decision.
Can I ask you, there's a related question about cases out of jurisdiction and again, our jurisdiction as well. But here the question is, are you aware of any case where a physician who had I'll make it broad, whether the physician had previously treated the patient or not, a physician is asked for advice, asked for ideas about a medical situation involving a patient, and either, by act or by omission, so by act gives bad advice, or doesn't give, by omission, doesn't give ideas that a good doctor would have given. And the court has said no liability in tort because, no physician-patient relationship or no legal duty, either way. Are you aware of any case that takes that form where the allegation is there was a conversation about how to deal with a patient and a doctor said, either said something that was wrong or didn't say something that a competent doctor would have said, and it's just that the connections were too tenuous, therefore no legal duty, no liability? Is there any case that's like that has gone that route?
Well, the closest of the cases that I'm aware of, the closest case that is analogous to that, I think, would be the Wilson, the Alabama case, where that was a treating physician, and we didn't get into the question whether it was bad advice or good advice. The question was who was responsible for the patient in that situation. But also, I would go back to Gilbert, because the obstetrician in Gilbert, I know he didn't perform surgery on the patient or have examine the patient like Dr. Shapiro had in the past, but that obstetrician was aware of patients and consulted, if you will, with the midwife, and there was no liability on the obstetrician for the plan that
the midwife of all the pertinent risks. In fact, he expressed he was unhappy that she was going to go ahead with vaginal birth, given those risks. So, I mean, nobody here is saying that Dr. Shapiro needed to override the judgment of Inovo. I think the only claim is Dr. Shapiro needed to relay the relevant information, which was undoubtedly the case in Gilbert.
But I guess my response to that, Your Honor, is in that conversation, one conversation, as limited as it was, how does Dr. Shapiro or any other physician know what's going to be relevant or not? This is not continuing contact between the Dr. Donani or Fairfax and Dr. Shapiro.
Mr. Gonzalez,
For all
I'm
we
sorry.
know, well, we don't know where
Sorry about the delay. I'm sure it's highly challenging for you to deal with our many questions, but I just have one question about something that you said in your brief, which on page 20, you refer to basically what looks like a test in the District of Columbia, under the District of Columbia, a test for when a consultant, might have a limited duty. And is this actually law in the district? The part of Gilbert that you're actually citing, I think, is the dissent, and the dissent is relying on an Ohio case. But what is your view of the sort of the status of this rule? It sounds like something that just the dissent is talking about that other jurisdictions have done.
That's correct, Your Honor. I think Judge Riz might be dealing with that. And I think he addresses that a little bit in Hedgebeth as well. But it is not the law in the District of Columbia that I'm aware of. I think it's dicta is probably the better way of describing it.
I'm sorry.
I would say that it's dicta, Your Honor.
Oh, okay. Thank you. Anybody else? Okay, Mr. Gonzalez, thank you for indulging our questions in the difficult issues technologically. We will give Mr. Adams 3 minutes or so for rebuttal. You're on mute, Mr. Adams.
Okay,
Yep, thank you.
thank you. As you know, I'm totally incompetent when it comes to computers. I have younger, smarter people around me. The only thing I want to say, and I want to make it clear, and I think it is clear to the court, is that the bar we set for Dr. Shapiro is not very high. We're not alleging that he was negligent in not superintending anything that Dr. Donani did, or even recommending that things be done. All we're saying, and I think our experts' opinions are pretty clear on this, is that when he's contacted by his patient experiencing stroke-like symptoms after having a procedure that has potential serious ramifications, all he needed to do was say, there is this phenomenon called an AEF, which I'm sure you're not aware of. This is what it is, and whether it's causing this lady's symptoms or not can be ruled in or out by the performance of a CT. That's all he had to say. Donani in our expert witness designation says, if I'd been told that, then I would have had a CT of her chest. But parenthetically, there was already a recommendation for a CT of her chest based on other diagnostic testing, not emergency or not stat, but it had been recommended. It wasn't unheard of in the circumstances. Dr. Shapiro had no obligation, I don't believe, and we're not asserting, to do anything proactively beyond that. And I think the record is somewhat clear, although it's a little fuzzy, that he did have contact with the people in Inova several times, and in fact went over there once. We're not really getting into that here because the bar is so low. If he had done what we're saying, he's out of it, and the Inova Fairfax people are on it, as they were in the other case.
Did you just say there was a separate recommendation for a CT test?
Yeah, there actually had been a recommendation. They did a CT of the brain, I believe, and there was a recommendation, not in a stat manner, saying that a CT, there was something in the lung that was a little sketchy. They want CT of the chest should be done at some point in time. That's kind of what it was. I don't know that Donani was aware of that.
I mean, that might be a pretty bad fact for you, counsel. It's awfully hard. You might have a bad causal case if there's already a recommendation for a CT scan that Dr. Donani didn't follow the recommendation of.
But it wasn't a recommendation for the stroke-like symptoms. It was a incidental finding based on another test.
I've got one other question. What's your response to Mr. Gonzalez's point that Anovo has its own experts? As a policy matter, you don't want doctors sprinkling liability around by placing calls to every other doctor they can find, maybe putting somebody else on the hook rather than consulting with their own in-house people who presumably could have said AEF just as quickly as Dr. Shapiro?
Well, I think that's true, and that was the subject of the litigation that has subsequently been resolved. That was litigated in Fairfax, but that doesn't.
What's true? I'm sorry.
There was a litigation in Fairfax, and that was part of the defense to that litigation. Mr. Gonzalez was not involved in that, but that was beyond Dr. Shapiro's obligation, we're saying in this case. That was a defense in the other case. Hey, by the way, you guys should have pursued this further, after Shapiro and all of that. That was a legitimate inquiry at the time in the other case.
I'm just asking for an answer to the policy question of, isn't it a bad idea to allow doctors to sprinkle liability around this way when they have the full opportunity to consult in-house people at the treating hospital center? I mean, that's part of Mr. Gonzalez's policy point. And I have to say, when I read this case law, it seems like a lot of this is judicial policy making. There's no statute really guiding us on these questions. So we have to take the policy point seriously.
No, I don't agree with that, Your Honor. In this case, this was right at the inception of this woman's difficulties. Obviously, Donani knew nothing about AEFs. Dr. Shapiro had the opportunity and the obligation, we're saying, to have educated him minimally at the outset. There's such a thing as an AEF. CT scan will tell if it's there or not. And Dr. Donani, good luck, you're the intensivist, and I'm not.
Anything further, Mr. Adams? Thank you both for your briefs and for your arguments today, and especially for your patience. This case will be submitted and we are adjourned.
This court is now adjourned. Counsel, you can exit out. Counsel Adams, if you can exit out.
You might have